Good afternoon, everybody, and I'm really grateful for this opportunity to be part of this interdisciplinary cannabis symposium, and more specifically, to be the moderator of such an esteemed panel of colleagues, because it is an exciting conversation we're going to get into about rescheduling versus descheduling, but more importantly, all the issues that lead into that conversation and how it impacts those of us across multiple disciplines in our thinking, in our strategic planning, and in our professional lives. So I am David Holland, and I am a 30-year attorney and advocate in the cannabis space, and I'm also involved with a number of advocacy groups, including Empire State NORML, which is New York's chapter of the National Organization for Reform of Marijuana Laws. I'm going to ask each of my colleagues to spend 30 seconds just doing a short bio, because everything is online already. But I would ask that in the course of giving your bios, I'd ask each of you just to state, what is it about the cannabis conversation that has driven you in your professional life to come to be a part of the panel today and this and part of this exciting conversation? Dr. Spett?
Can you all hear me okay? Great. So I'm Kevin Sabet. I'm the president of a group called SAM, Smart Approaches to Marijuana, that I started when I left the Obama administration in 2011. I served the White House 3 times, most recently in the Obama administration, where I was a lead on marijuana policy. I also have an affiliation with Yale University, and I realize I'm probably on the minority here on the panel, but I'm looking forward to having a good discussion on these issues. What motivates me is really something Barack Obama told us as appointees. He said, you can disagree without being disagreeable. Remember those days? That seems like a very long time ago, but a little ancient history. But also having grown up in an era where the tobacco regulations had changed. You know, when I was 8 years old, we'd go into a restaurant, smoking or non. We'd buy airplane tickets, smoking or non. By the time I was 18, that was totally obsolete. An incredible transformation of public health driven by a lot of things. Mainly, we found out that big tobacco was lying to us for 100 years. And laughing all the way to the bank. And that's my chief concern with the marijuana issue. I think this is all about money. I think that's why we're talking about it. I think the social equity concerns are used as a veneer for the profit motivation. And my biggest thing is, which I think we'll talk about, is I think we have set us each sort of this debate up in a wrong way. We've set it up as a false dichotomy between legalization or commercialization, which is what it's turned into, and prohibition or criminalization, as if you have those are your only choices. I think that's a false choice, and I hope we can talk a little bit more about that today.
Great. Professor?
Hi, I am Rob Mikos. I'm professor of law at Vanderbilt University in Nashville, Tennessee. I'm one of those other places that has fairly strict laws governing cannabis, among other substances. I've spent maybe the last 15 years focusing the bulk of my research and writing really on all the interesting law and policy issues surrounding cannabis. And what got me into this area was all the confusion over, what's the role of different government actors in this particular space. We have a bizarre system now that's sort of a hodgepodge of state and federal, local policies regarding cannabis. It's being rolled out to other substances as well. And I think we're really doing a disservice to the nation when we allow certain lawmakers or certain regulators to kind of hide behind this confusion oftentimes. There are some times when a lawmaker will forego a particularly popular policy choice because they say, I just can't do this. My hands are tied. When that is factually incorrect. Other times where you'll get a policymaker doing just the opposite. They'll claim that they have the authority and no one else can call the shots. And so what I try to do isn't so much on the substance of the policies, though I do get into that, but I try to settle these disputes and really illuminate what's the actual authority of different actors in the system, because I think that can help to clarify some matters and maybe help us make better decisions on the substance.
All right, good morning. My name is Jennifer Cabrera. I am a partner with the law firm Vicente LLP, which is a Denver-based law firm that works exclusively in the cannabis and psychedelics hemp space. I joined that firm in 2019, launching our New York and New Jersey offices. However, unlike many of my colleagues, my background is not in advocacy or activism, because when I graduated law school in 2006, cannabis law was not a job. So I did use cannabis when I was in law school. And I can tell you that back in those days, I was in the minority, and it was certainly not something that we talked about. Rather, this is something that came up for me in 2019 when I joined this firm. And it was really something where I started doing the work. I enjoyed the work. I found that cannabis had been helpful for some of my family members. And also for me, I'd found that it didn't lead me to harder drugs, and I liked the industry. So I ended up becoming a cannabis practitioner. And much of my job is going around municipal governments in New Jersey, especially where they have quite a lot of municipal control, talking to planning boards, talking to city councils, talking to people who show up for those meetings, and addressing their concerns about dispensaries moving into their towns or cultivation centers. So that's what I do, and nice to be here.
I'm Dr. Peter Grinspoon. I'm a primary care doctor at Massachusetts General Hospital. I also work in their addiction clinic there. I teach at Harvard Medical School. I've been involved in cannabis basically before birth. All the way since to the present, because my father was a kind of a giant in the legalization movement. He was a psychiatrist at Harvard as well and a cannabis scholar. He actually wrote a book in 1971 called Marijuana Reconsidered, which some of you might know about, which sort of got the legalization movement going. At that point, only 12% of people supported legalization. Now it's about 70% support full legalization. Republicans, Democrats, independents, and about 90% of people support legal access to medical cannabis. Both presidential candidates actually support legalization. I wish my dad were here to see it. The other thing is, when I was growing up, my brother Danny, unfortunately, was fighting a losing battle against childhood leukemia. But when I was growing up, my parents, unfortunately, legally purchased his cannabis for him right during Nixon's war on drugs. Of course, as we'll talk about, now we know that Nixon didn't even think cannabis was dangerous, and he was lying about the whole thing. There was never a public health component towards criminalizing cannabis, but we'll talk about that as well. I saw how it helped my brother when he was on chemotherapy and he didn't use cannabis. He would just be alone in his room throwing up into a bucket. And when he used cannabis, he was able to eat, to hold down food, to play his guitar, which gave him a lot of joy, and most importantly to us, to play with his little brothers. So I became interested in legalization and in medical cannabis. And I've been treating people with medical cannabis for about 25 years, of course, a little more openly now that it's actually legal. And I've been involved in the legalization movement, and I'm now writing my second book about cannabis. It's going to be about cannabis and seniors, because seniors are very widely adopting cannabis, and they're finding that it really helps them with polypharmacy and helps them obviate the need for more dangerous pharmaceuticals. So I'm really glad to be here and to be part of this great panel.
So it's sort of funny. It's, with everybody mentioning they're in the minority, I might as well come clean to that. I think I'm in the true minority, which is I stopped smoking cannabis when I was 18 years old. It just no longer was for me, but I found it part of the passion of some of the things I fight for. But when I worked for a dozen years at High Times Magazine, everybody thought I was an undercover Fed because I wouldn't smoke pot with them. So, so we all have our experiences. But it's an interesting, now you understand why I'm so excited about this conversation, given the experiences, backgrounds, and perspectives of each of the panelists here. And so in order to get to the conversation about descheduling or rescheduling, I think it's important to start out with the historical perspective, which is just a brief setup to the conversation I want to have, which is, as many people know, as a colonist, or the history of the colonies in the United States revolves around cannabis, because you were required as a colonist to actually cultivate it for the purposes of various economies, both here and back in the homeland in England. As that over the years evolved, we started to see a change in the early 1900s with a view towards, with the Harrison Act and a view towards regulation of certain drugs, of which cannabis was mentioned. And then 36, you saw what I heard earlier in panels mentioned also, which is the Marijuana Stamp Tax Act that really started the, what would be the consideration of the elimination of that plant from its roots in our society, quite literally. for those, many know that Harry Anslinger was one of the driving forces of that, and I imagine, given the sophistication of the crowd here, everybody's pretty familiar with the racist sort of bent with which he pursued that campaign. That campaign comes to fulmination in 1970 with the Controlled Substances Act. And that then places cannabis, at least what was supposed to be temporarily, in Schedule I, making it a prohibited substance based on 3 qualifications of lack of medical viability, lack of being able to conduct research without stringent control, and the third, forgive me because I know I'm going to be bringing it up and it will be brought up by the others as well, but it's these were the factors by which it was placed temporarily into that. And we've learned in just recent times, there, as was just mentioned, that Nixon apparently wasn't necessarily one looking for the draconian sentencing and punitive incarceration that later became to be embodied within the Controlled Substances Act and also within state laws. He thought that a 30-year sentence was ridiculous, was one of the quotes that I read. We also know from Ehrlichman, who had been his chief of staff, that there's the famous statement that he gave to Harper's that it was really more about social policy and putting down political dissent than it was about the science. So my first question, I think this will start out with both Dr. Sabet and Dr. Grinspoon, is was science really behind the Schedule I designation more so than social policy? And if not, has the science subsequently justified that position through multiple administrations over the last 54 years? I want to start with that. And Dr. Sabet, given your experience with 3 administrations, what is, in your opinion, were the driving forces of that original designation and its continuation of that designation through the administrations you served?
Sure, thank you. Well, actually, it's a very prescient question for me because I'm also in the at the very end of writing a book called One Nation Under the Influence. That a lot of it, the first part of it, is history of drug laws. Interesting things about history. A couple of things that you may or may not have known. Number one, Mexico banned marijuana before we did. They saw there are documentation, if you look at the Mexican Congress in the 1800s and early 1900s, of essentially what they're describing as versions of psychoses and sort of out-of-mind experiences that they wanted to prevent. It was banned in the rest of the world, most of the rest of the world, before the United States proceeded to sort of have a patchwork of different kinds of laws. Harry Anslinger certainly was probably motivated somewhat by some racist instincts. Then I dug a little bit deeper, spoke to people who actually worked with Harry Anslinger and especially a lot of black and brown people that actually worked for him, and talked a little bit about how that story has been a little bit simplified in the history. But again, that's something that we can sort of debate historically, whether we not want to or not. Richard Nixon's a very interesting case. I don't think, first of all, anybody is going to say these days, including myself, that we want a 30-year sentence for anybody using marijuana. In fact, what I'm saying is we should not criminalize marijuana, but I'm saying we should not legalize it either. That there is a middle ground where you can discourage something without putting somebody in prison, giving them a stigma of an arrest. Somebody said over here, well, everyone will use drugs, so we should sort of figure out a way for them to use it and sort of use it safely. The way I see that is sort of like speed limits. Everyone will speed. A lot of people will speed. Most people who speed won't get into a car crash. That's not a reason to encourage speeding. In fact, we know that when you speed, you increase your risk of something bad happening. And so that's why we're trying to discourage it. We wouldn't give someone a 30-year sentence if they went 10 miles over the speed limit. So it's about proportionality. That's how I see it. Historically, Nixon is a very interesting case because I don't know how many of you knew this or not. This is just a fact that Richard Nixon actually ushered in the biggest expansion of drug treatment, mainly for heroin users, methadone maintenance and others, than any other president before or since, maybe with the exception of Barack Obama and the and Obamacare, which helped 60 million Americans get treatment. But before that happened, and I'm very proud to have been there for that, before that happened, it was actually Dick Nixon, and whatever he was motivated by, his drug czar Jerry Jaffe at the time, who was a Democrat, is a Democrat, still alive. They ushered in more drug treatment, actually, than any other president. Really interesting. So I think there's a lot of the history that's been a little bit oversimplified in terms of, well, this is a racist war on drugs, and Nixon was completely racist on this, and that's why wanted marijuana to be 30 years. No doubt Richard Nixon did not like the hippie movement, right? There was a generational war, a culture war at the time. There's no doubt about that. But I think the history is a bit more nuanced. To answer your question, the last part of your question, and I want to hear what everyone else has to say. You know, a lot of, you know, George Washington and our, founding fathers were brilliant. They also did a lot of things and practiced a lot of things that wouldn't necessarily be proud of. We did a lot of things in 1787 that thank God we don't do now, because we've learned better, hopefully. And so thankfully, the marijuana science, I mean, you cannot compare even 30 years ago to today versus 50, 70, 80, 100 years ago in terms of what we know. And the reason why every single medical association in this country, despite some of the folks here, and we might have friendly disagreements, but every single medical association in this country warns against cannabis use. They are almost in uniform against its legalization. And where they open the door to legalization, they say at the very least we need a lot of public health measures and guardrails, which no state has effectively implemented, because these laws are written by people, and it goes back to the money, who are there to make money, not there to worry about whether youth should be prevented to use or not, or whether impaired driving is a concern. So I'm really coming at it from a perspective of, I'm going to keep going back to this false dichotomy we are presented with criminalization and the war on drugs, sort of no research, this is all bad, or what we have now, which is New York City has been changed. If anybody walks down the street, you will figure, your nose will figure out how much New York City's been changed in the last 5 years. But beyond that, this mass commercialization, which you thought we would have learned.
I'm going to stop you there for a second, Doctor, just because we're definitely going to come back to that. But Dr. Grinspoon, so you just heard one of the explanations is we may also know much more today than we did 30 years ago about it. So therefore, the question about whether science justified the actual designation way back when comes into question to some degree. But you, as a primary care physician, knowing now what we know 30 years or what we've learned in the 54 years since it went into Schedule I, what is your thoughts on it, and whether the science justifies such a restrictive schedule?
Well, first of all, it's important to remember that cannabis has been used by humans for 10,000 years, probably longer, in every society. Medically, for spiritual purposes, it's been used in Egypt, it's been Middle East, China, Asia. And so it's been criminalized for about, I figured this out when I was writing my book, about 1.6% of the time that we actually have been using it as a species. So it's really, it's been profoundly helpful for humans. I mean, it kind of makes sense that anything that makes you kind of mindful, present, focused, hungry, horny would help our evolutionary prospects. But, science, the only thing that hasn't contributed to the whole debate about legalization or criminalization is science. It's been everything else. It's been racism. It's been competing commercial interests. It's been just a lot of nonsense. I mean, you just look at the Shaeffer Commission, beyond the fact that Nixon, there are now these tapes saying that Nixon didn't even believe it was harmful, which is just a whole nother conversation. It's just horrible. But he had a Shaeffer Commission to investigate what are the dangers of cannabis. Is it dangerous? And his own handpicked committee in the early 1970s said we should decriminalize it. So even his committee said that it wasn't scientifically based to stick it in Schedule I. And, he decided to ignore it for political purposes, as David sort of highlighted. Then a lot of the research, unfortunately, was very much influenced by the war on drugs. A recent study came out in Science magazine saying that the funding into harms was about 20 times the funding into benefits. Of course, we do need to know the harms. With any medicine, we need to know the harms and the benefits. I think it's crazy that the pro-cannabis people don't want to know about the harms, and that the anti-cannabis people won't really concede that it helps people. I think there's a lot of common ground, but we could talk about that later for cannabis. But to do any cannabis research, to get funded by NIDA, or the National Institute of Health, which funded 80 to 90% of the drug research worldwide, you had to show that cannabis causes a harm. You had to drop IQ or motivation or sperm count, none of which turned out to be true. So our science sort of has been shaped to fit the Schedule I classification. The Schedule I classification had nothing to do with science. And luckily, this is starting to change. And again, our society as a whole has been waking up to the fact that a lot of this is real nonsense. I agree with legalization. We need regulation to keep people safe. I mean, certain people shouldn't use cannabis, people with psychosis, a history of psychosis, pregnant women breastfeeding, people with cardiac diseases, teenagers. But if you take that away, cannabis is much safer than alcohol, which killed 172,000 people last year. And it's kind of ironic that we're giving away alcohol as gifts to people for this conference on cannabis, which is more dangerous. But so in short, I think that Science was the one thing that wasn't considered or wasn't legitimately neutrally in a curious neutral fashion considered in making it Schedule 1. And then finally, just have to rebut one small thing my friend Kevin said. The medical societies are fattened by pharmaceutical funding. And they are so out of touch. And 2/3 to 3/4 of physicians believe cannabis is a safe and effective medication, obviously, particularly oncologists and primary care physicians. But, you know, the American Medical Association in 1937, when they were trying to criminalize cannabis, was one of the leading voices against criminalization. Then they were sort of beaten down by Anslinger and by the DEA, and now they're against it, but they don't represent most doctors. I mean, back then, 80% of physicians were part of the American Medical Association. Now it's 12%. So they're really losing their audience. So anyways, my answer is resounding no. It was everything but science that put us into Schedule 1.
So, Ms. Cabrera, that really leads us to an interesting situation then. If profit in one person's perspective has been the motive and science is another one saying that it shouldn't be so restrictive, Vicente is one of the leading law firms in the country, no doubt, and has been very involved in the medical rollout of the cannabis programs as well as the adult use programs. But from a medical perspective in clients that you've helped, there's no doubt that pharmaceutical companies and drug manufacturers have a profit motive. There are very few not-for-profit organizations out there in drug manufacturing. So I'm not sure that sets cannabis apart in any other way. But have the science with which your medical clients have developed, has that helped clarify, in your opinion, one way or the other, the science behind the designation of Schedule 1?
I would agree that a profit motive is present in pretty much everything that comes out in this country. Like the end of prohibition of alcohol, there's a profit motive, right? We've had so many articles over the last 20 years about how alcohol is good for you, actually. It's actually very useful in moderation. And those have all been really rebutted in the last 5 years or so, that the research was bad. There is no safe amount of alcohol. It's just bad for you. It gives you cancer. It gives you all other kinds of problems. I mean, I do drink once in a while, but I also know it's not good for me. There are a lot of things out there that are not good for me. When I have 2 children, when I was pregnant, I didn't use cannabis. You know what else? I didn't use pseudoephedrine. The second time I was pregnant, I had a kid in daycare, which meant I got all the colds. That kid brought every single cold home. I constantly was sick, but I couldn't take pseudoephedrine. You know why? Because it wasn't good for me and it wasn't good for the baby in my belly. So people can make informed decisions about what is safe, even if it's not completely safe, right? It's the dosage that makes the poison. So when it comes to cannabis, yes, we support legalization. I support legalization because there are a lot of things out there that are unsafe in different dosages, but they're legal and it's up to people to make that decision. So in terms of my clients, I think that there's the question of what did Nixon think seems a little bit irrelevant because number one, he wasn't a scientist. And now it seems quite clear that the potential for abuse is just not at a Schedule 1 level for cannabis. And we have all of these legal medical programs and adult use programs across the country in red states and blue states. And we don't have people dying. No one dies from cannabis. You can kind of smoke yourself to a point of oblivion, but you don't die from it.
I have to take a point of privilege there. I literally got a phone call yesterday from a woman in Colorado whose son was high on THC and, you know, jumped off of a 6-story building because he committed suicide while he was in a THC psychosis. There are 25,000 people a year who are killed or injured because of cannabis-related car crashes. So this no one ever dies thing, I think, is it's a great talking point, but I think it's really not sensitive to the tens of thousands of families. It seems like people are sort of stuck in this time warp of cannabis when it was 1% THC or Nixon's time. I think it was 2.5%. We're talking about a different drug here for the last couple of years. This industry has produced 99% THC crystallines that are these highly potent waxes. We barely know what they do other than for some people cause psychosis. So number one drug in suicides among youth, it's marijuana. It's not alcohol in Colorado, in your state. So I really think we need to this cannabis doesn't die thing is just not fair just because you don't overdose. You don't overdose on cigarettes either. They kill 400,000 people a year through lung cancer.
Right.
You don't die from an overdose. So that cannabis doesn't die thing, there are benefits, and I'm not saying there aren't any, but let's not overdose.
But there are different there's a different correlation there, right? Because it might lead you to do something stupid and that gets you killed. But
Right.
that's different from alcohol, which actually killed my brother-in-law. So there are drugs that can kill you. This is not one of them.
Well, can I just mention
Yeah,
that
it's
the
a
other,
different way.
there are other drugs that cause psychosis as well. Alcohol causes psychosis.
And
It's
not
not
nearly
illegal.
the
No. It's
marijuana.
yeah, 20 to 25%. It's very close. Steroids, psychedelics, you just heard about. Amphetamines, your Adderall, high dose Adderall can. So
Yeah, we should
there's
discourage
no
all that too.
argument for criminalization and
I'm
for
not
throwing-
criminalizing people, but two wrongs don't make a right. If my headlights are broken, I don't break tail light just to be consistent.
Okay, but
You know, we should
before
learn
we
from
go
it.
down to
Well,
those
that's
bad
consistent.
analogies, which we'll get back to, there's no doubt. And, let's just keep in mind the number one killer of children in America today are guns. So it has nothing to do with cannabis. But what I want to go to is Professor, with this taking a legal perspective of where there's social policy is clashing with science, and clearly what we're hearing is science is becoming more and more updated as not only cannabis is around longer, but also with greater rollouts of legalization programs, both medically and adult use. Is there a constitutional right or a constitutional angle by which this needs to be evaluated, both by the courts and by society and by individuals in their right to pursue medications that may, or intoxicants just on a personal use basis? Is there some prevailing constitutional right that allows that to go forward?
I would say emphatically no. At least at the federal level, it's pretty well settled that you have no fundamental constitutional right, due process or otherwise, to use any particular substance. That the Supreme Court has closed that door and locked it and thrown on chains and so on. So the Constitution is a bit of a dead end there. There are ways of reimagining what that right is. It's not a right to use a particular substance, but rather a cognitive liberty, a right to think in a particular way or to change your mind. And Dustin, one of the prior panelists, has written in that particular vein. But there's no constitutional right itself to do that.
Well, so let me ask you this then, Professor. Federal preemption, which is a constitutional a mandate, if you will, that federal law will preempt all state laws. And obviously we've found an exception to that through the Ogden and Cole memos and so forth that have allowed these various programs to roll out, at least medically. Adult use is still a little bit more of an interesting question. But there has been a lot of science, going back to the original thing, that has been developed out of these state programs. But is there any preemption of the ability to use that science and those results as part of the evaluation, what is now going to be the upcoming DEA evaluation and hearings that are going to take place?
I don't think, I wouldn't describe it in preemption terms necessarily. Instead, what we need to look at are what are the standards that Congress kind of set up for these administrative agencies to use when they were making these administrative rescheduling decisions. And I want to suggest to you, if we go back to that period, 1970, it could very well be the case that the reason Congress placed cannabis, marijuana on Schedule 1, it was a social reason. It was to suppress disfavored minorities. It was to suppress the counterculture. Maybe that's really what was driving them rather than concerns about science or health. But Congress, in a sense, said, do as we say, don't do as we do. It instructed the administrative agencies, hey, here are some objective criteria you could use to revisit all of these choices we made circa 1970. And I think those are all going to be based on science. And those are things like whether a drug has a currently accepted medical use, its dependence liability, and its potential for abuse. And they're all really science-driven. As part of that, now it's up to the agencies, I think, to kind of define what exactly Congress meant by each of those. And so the agencies could look at that and say, well, we're going to look at this potential for abuse criteria and look at what's happened in the states to help us analyze that particular factor, to determine with cannabis in the states that have these medical cannabis programs, how much of a potential for abuse does this drug really have? I don't think they're foreclosed from doing that. It's just that they made a choice early on that they were going to tie this statute, the Controlled Substances Act, at least in part to the Food, Drug, and Cosmetic Act, which really is a lab-centric statute. It's a statute that says it's got to be evidence, scientific evidence that's culled from randomized controlled trials. Pretty much nothing else matters at this point.
So, and that's great. The commonly accepted medical use was the thing I was trying to think of earlier. Dr. Shabet, so you have a lot of experience through the administrations you served. My understanding was there's a 5-step evaluation in terms of scheduling and rescheduling, and there has been a recommendation that that be reduced down to 2 steps. Can you explain that briefly to people? And then I've got some follow-up questions.
We have better experts on that in this room, but just very briefly, you know, I think there's a lot of misnomers around scheduling. Making it Schedule 3 will not legalize marijuana. So that's the first thing that people think wrongly about it, number one. You know, number two, there is yes, the criteria you mentioned, there's sort of this 5-part test to determine, because basically schedules, it's about currently accepted medical use and, you know, sort of abuse potential, dangerousness, essentially. And I think, first of all, people think that in some ways the scheduling thing is like a harm index, like drugs in 1 must be more harmful than drugs in 2, but that's actually not the case. Cocaine has been in Schedule 2 for years because we know that it has a very limited, in a hospital setting, very limited medical use. So by definition, it cannot be Schedule 1 because even that very rare medical use automatically makes it a 2 through 5, and so it was put into 2 because it has a medical use. The thing what happened this time that I was actually very surprised when I saw the Schedule 3 recommendation, to be honest with you, because, you know, NORML's been trying to do this for, I mean, was your dad ever a petitioner? I mean, for 60 years.
He's the executive director of NORML.
At the time, yeah. So, I mean, his dad was, I mean, they've been trying to do this since 1970, I think, basically say this should not be in Schedule 1. They've lost every single time. This time when they said, well, no, it should be in Schedule 3, I really started scratching my head because now the FDA has redefined the way they've always looked at a medical use. And they said, well, accepted medical use, now ready for this, does not mean approved medical use. Like, well, wait a minute, what does it mean then? Essentially, what they said was, we think it should be Schedule 3 because basically the majority of states and a lot of people think it's medicine. So it has accepted medical use. It's accepted. It could be wrong, but it's accepted. And they cited some studies, some of them were actually quite obscure on anorexia that I've never seen cited actually in any of these kinds of things. And they came to this conclusion that because it has accepted medical use, even though it has not been approved by the FDA at all, in terms of cannabis as a whole, not its individual products, therefore it should be Schedule 3. I was very confused by that and still am. I don't know how but they, like you said, they redefined how you got there. So that's going to be something we're going to look at for a very long time. We still don't know what they're going to do. But the misconception is it's going to legalize marijuana. It will not. The other misconception is this scheduling means one drug is worse than the other. And so how can heroin, I mean, even the vice president said this as well, wrongly. She said, well, how can this be a Schedule 1 that makes it worse than fentanyl? Because fentanyl is not a Schedule 1. Fentanyl has medical use. It can't be Schedule 1. This is a fundamental misreading, I think, of the Controlled Substances Act. And I'll just close with this. The analogy I like to use is like a snack aisle in a convenience store. You might have Doritos and bananas in aisle 1. That doesn't mean that Doritos and bananas are the same kind of thing. But according to the manager, you know, they fall under this definition of, you know, I don't know, take-home snacks. And so there's a little bag of Doritos and then there's been a single-use banana. They're both in aisle 1. It doesn't mean bananas are the same as Doritos nutritionally. It doesn't mean that bananas are worse for you than the Oreos that are in aisle 4, which is the cookie aisle. It just means this is how they're defined. Cocaine in Schedule 2, the penalties are much worse than marijuana in Schedule 1 because scheduling is not about mainly about the jail time. Scheduling doesn't really, except for some very limited federal circumstances, determine prison sentencing. So I just think there's a fundamental misreading of what scheduling does, and I think that's a problem.
And thank you for that. I'm not sure I would agree on the sentencing thing, but I don't want to go there. But what I did hear is what I think is really interesting. So it creates a 2-part question. First, Dr. Grinspoon, to you, which is talking about commonly accepted medical use as somebody who's got a long experience in the exploration of cannabis and its modalities with interventions in medicine, but also to the lawyers on the panel. So what should be the evidentiary standards? You know, there are the Fry test and the Daubert test. And, you know, should it be accepted across how wide a body of medical practitioners or scientists before it's considered to be, quote unquote, a valid expert opinion? And you may not have an answer to it, but I'm curious as to what the evaluative factors might be in a consideration of that as we're nearing this December 2nd hearing date. Doctor, starting with you, with commonly accepted medical use, what are some of the things that you have found that are accepted medical uses of it, or things that should be considered when they go into this hearing?
Well, it's not just me. I mean, the National Academy of Sciences, Engineering, and Medicine in 2017 concluded that it was helpful for pain, chronic pain, particularly neuropathic pain, helpful for people with insomnia who are in chronic pain, helpful for chemotherapy-induced nausea and vomiting. So by, Kevin's argument, they have medical uses is safer than fentanyl. Of course, it shouldn't be in Schedule 1. But what I treat people with is mostly chronic pain, anxiety, and insomnia. And, it's impossible to argue that cannabis is more dangerous than like Ambien or oxycodone. So I think that, it's interesting to remember, too, that cannabis was put in the United States Pharmacoepia as an accepted medication by physicians in the medical community in the 1850s. And then after this very horrible racist war on drug, Anslinger, it got taken out of the Pharmacoepia in the 1940s, and it's going to be put back in the Pharmacoepia. Again, it's impossible to argue that cannabis doesn't have medical uses. The thing we could argue about is harms and how dangerous it is. And I think there's actually a lot of common ground. People agree that it can destabilize people in psychosis, that we don't know if it's safe in pregnancy. Of course, what is safe in pregnancy? As you brought up, like, woman has really bad sciatica, we have to treat her with something. Nobody wants to give nonsteroidals or opiates. So I think Schedule 1 is just like.
Can you define it though? Like when you say cannabis, I think it'd be helpful. Like when you say cannabis, or because like
Right.
Pharmacopoeia was 1% THC. I mean, it wasn't these edible, gummy bears.
Well, firstly, yeah. Well, I mean,
What does it mean?
well, it is cannabis has 500 different
Right.
components in it, different strains, different
Right.
types. Some are good for some things. Some make people more anxious. Some people make them more energetic. Some people make them more relaxed, help with chronic pain. Several components of cannabis are FDA approved medications. Marinol was approved in the 1980s, and Epiledex was approved very recently for CBD. So again, it's impossible to say that it doesn't have medical uses. Again, I agree that if people are blasting themselves with really, really high levels of THC, that certainly could contribute to substance-induced psychosis. But the question is, what do you do if you criminalize it? It just goes into the illicit market, and then you have even less control over it, and it makes it harder for people to get help. So I really, really disagree with Kevin. I think legalization with regulation, not just a free-for-all, and with really a lot of money, spend the money on the taxes. In Massachusetts, we made a lot more money on taxes last year from cannabis than from alcohol. Use the money for education and for public health.
What are they using the money for?
Well, a variety of things. Some of it for education, and some of it, unfortunately, goes into the general fund of the states who spend too much money on everything else. You're still generating revenue. But I honestly think that I don't even think cannabis should be scheduled. If you compared it to alcohol and tobacco, it makes no sense. The whole law enforcement approach to cannabis never was started in the right foot. It wasn't the right thing. Against the American Medical Association was against it from the very beginning, and it's just the wrong. It's like a square peg in a round hole, or I'm mixing metaphors here, but it just criminalizing cannabis hasn't worked. It's been a complete failure. We can't brush under the rug that more than 20 million people that have been arrested for nonviolent cannabis offenses, mostly people of black or brown skin. And that affects your employment, your education. It causes generational poverty. It affects your housing. And there's no circumstance when using cannabis is worse for you than getting entangled with the criminal justice system, especially if you're a minority. So the criminalization has been a disaster. And I think we need to be focusing on how to overturn the criminalization and how to re-legalize it, not legalize it, but re-legalize it in a sensible way that protects public health.
Okay, so then going back to the question, though, about commonly accepted medical use, this is now a question for Ms. Cabrera and Professor Mikos. Since federal law, preemption is not the right word, but these have not been subjected to what had otherwise be considered, the standard protocols for federal investigation of drugs. But you have a lot of state programs that have been out there that have done very in-depth research into the results, not only of their markets, but the treatment of different conditions that are out there, as well as researching just people who are using it as a personal use intoxicant. What should be, or the approach by which evidence should be put before this hearing officer to try to sway whatever outcome in every direction that this would go? And I'm not trying to take anybody by surprise on an evidence lecture and on law, but there's got to be something that's going to be the evaluative factor, which I'll just contextualize it because it was brought up by Dr. Sabet. In 1974, Normal challenged the scheduling of cannabis, and it was Judge Young, an administrative law judge, who felt that, and while he did not believe it was personally should be in Schedule 1 and it did not meet the criteria for that, he felt restricted by not only the statute itself, but also the administrative agencies that interpreted it. And it's an interesting thing in this post-Chevron era, for those of you who are not attorneys here, the judicial bench no longer has to rely or be constrained by a agency interpretation of a congressional law or statute or bill. They're now free to come to their own conclusions, but take that into account in doing that. So with that in place, it makes an interesting conversation for what this hearing should be designed like. What do you think?
Well, I think first off, I think the Office of Legal Counsel, which is a prominent part of the Department of Justice, it's already settled this issue. Because the Office of Legal Counsel, I think there were questions raised by members of Congress as well as the DEA after the FDA had recommended the rescheduling of marijuana. There were questions raised about this new two-part test that the FDA had used to discover that marijuana now has a currently accepted medical use. And the Office of Legal Counsel basically said that test is reasonable. We're going to use that test. And the DEA has no power to second guess that now. The Attorney General can order the DEA to apply a certain standard of law. And that standard basically allows the agency to look at evidence beyond the traditional lab-created evidence like randomized controlled trials. That's how the FDA kind of concluded that marijuana has a currently accepted medical use. But I think there's a separate issue that we've been kind of sidestepping here, which is that we're placing way too much emphasis on this one single statutory scheduling criterion. And that's the fault of the DEA. It's a misinterpretation, a butchering of statutory language that goes back about 50 years when the DEA came out and said very explicitly, we don't care what the potential of abuse is for all these substances. They're on Schedule 1. Doesn't matter at all until you demonstrate to us that it has a currently accepted medical use. Until you demonstrate to us that it has a currently accepted medical use, it could have a low abuse potential, very low dependence liability. It still has to stay on Schedule 1. And that is just a terrible, terrible reading of the statute. If you say and acknowledge that that reading is wrong, then what you have to do is you have to say, okay, maybe there's some evidence of currently accepted medical use. Maybe we're not quite there yet, but now these other factors like the harms become more important. The things like the potential for abuse and the dependence liability of a substance. And then you have a more holistic view of where a drug belongs on the schedules. I disagree with Kevin's point that, this Controlled Substances Act doesn't aim to kind of place drugs on different schedules according to their harms. That is the whole reason why Congress layered this additional statute on top of the Food, Drug, and Cosmetic Act. It's all about making sure that the most dangerous drugs are subject to the most strict controls. But he's correct insofar as he's just saying, well, that's what the DEA has always done. DEA has never cared about harms. It's only cared about medical benefits. And I'm just saying that's wrong as a matter of law.
Jen, is there particular evidence that you would want to see put forward with regard, and particularly given the perspective of being a national law firm in this regard, that might be influential in that outcome of the hearing?
I think we have quite a bit of evidence just over the last 10 years, the number of state legal programs, both medical and recreational, and just we've now have a little bit more research that's coming out in this space, and it's clear that there are medical uses for it. So I think if we're looking at it from that perspective, there seems to be that evidence at this point.
So I think I'm going to go into something that is going to be directed to you. So commonly accepted medical use is not the only criteria, and I know that we've just talked about harms, and I know one of the things that I've seen you in multiple publications have raised concerns about children. And you mentioned it earlier, psychosis and psychosis-induced intervention by cannabis. Speak to us a little bit about that, whether that's one of the factors that should be evaluated in it. And then let's talk about what are some of the studies that lay behind those conclusions that you've seen.
This goes to a little bit what Rob's saying. Yeah, I do definitely think that what we've learned in the last 20 or 30 years is, of course, we've learned about certain benefits. There are hundreds of cannabinoids. We should absolutely do research into this medical potential. I'm a big supporter of these FDA-approved drugs that go through the proper mechanism. Neither voters nor judges nor elected officials should determine what a medicine is. That doesn't make sense. We don't do medicine by popular vote. So let's go through the science, make sure that science is funded, not politicized, and do that. On the issue of harm, though, even though we've learned a bit about medical benefit, of course, and again, I'm conceding that, over the last 30 years, there's no question how much just exponentially we have learned on the harms of today's highly potent marijuana. And actually, we don't really know about the super high potent stuff because that hasn't been really studied yet. But when you look at 10%, 15% THC, which is still a lot higher than what it used to be, you don't have to look to America. You can look to the UK, you can look to Australia, New Zealand, multiple countries that have really all come to the same conclusion about mental health and increasing, not decreasing, depression, anxieties, psychosis, schizophrenia, increasing, not decreasing, even the studies on pain, which is interesting because obviously there is evidence also on THC and pain. So I think people should just not necessarily take any of our word for it, just do your own literature review yourself, see what we're talking about when it comes to cardiovascular. Absolutely, when it comes to IQ, potential 8-point IQ loss among regular users and adolescents. I mean, all kinds of different studies that the National Academies of Sciences, Peter, because you talked about them, came out with their report 2017 and the report that just came out, 2 days ago, which made all this stuff very clear. So I think people should look at that themselves. In the context of this panel about rescheduling, and it goes to Rob's point about harm and do we take in consideration the harm, I've always wished we had a very different scheduling system. As much as I think marijuana should remain in one for various reasons, I think we should have a different system. Either one that allows for more research. So just because something's in Schedule 1 should not make research really hard to do. And there are many people doing research on Schedule 1, but I agree with Peter, like we can make it easier. There's no reason we should make it so hard. So you could have a 1A, a 1R, some kind of analog to the 1. The other way to do it is you could have a grid where you could have A through E and 1 through 5, where you have a drug. Let's say the 1 through 5 is about harm and the A through E is about medical potential. So fentanyl would be in the highest when it comes to harm, 1. But because it's sometimes used, actually often in medical situations, maybe it's a C out of the A through E of medical. So maybe it's a 1C or maybe it's a 3A. And marijuana maybe is a 1B or a 2A or something where it actually takes the scheduling discussion, which I really think is a technical discussion. It's a scientific discussion. It has been totally politicized now. It takes it away from this, I do think, misleading thing about 1 through 5. Because I think marijuana should be in Schedule 1. It's not because I think fentanyl is less harmful than marijuana. That of course I don't think that. Because marijuana should be in Schedule 1 is not because I think all kinds of drugs that are in Schedule 2 are more harmful than occasional use of marijuana. So I think the scheduling system itself is a bit outdated, needs to be updated to reflect the nuance of these new drugs, the deltas. We just heard about all those THC drugs. I think we could do a lot more. Maybe there is some common ground there. Absolutely. But the final thing I'll say, because it was brought up about state legal programs, even though that's not about scheduling, but it was brought up. I'm still waiting for the tax revenue to pay for prevention. I'm still waiting for the social equity programs to mint millionaires among Black and brown population. I'm still waiting for the arrest disparities to go down. The National Academy Friday said arrest disparities have gone up after legalization, not down. That's because if you're dealing with an inherently racist system and you believe the criminal justice system has those racist foundations, legalizing marijuana isn't exactly going to fix that. And I think we have totally overpromised. Frankly, a lot of rich white guys have all of a sudden said they're the civil rights leaders of our time because they're in favor of marijuana legalization. We have not seen any of those things happen. In fact, the disparities are widening, they're worsening, and now we have more people, especially people of color, using marijuana every single day. High potency marijuana, not the stuff, Peter's dad was talking about. High potency marijuana every day than alcohol every day. And you can't say, well, that's good because they're substituting. They're actually using them often together. So it's not a substitute. But also, that's not good when you're spending every waking hour stoned. Good luck getting a job if you don't have connections. Good luck getting a bank loan to open your pot shop if you aren't connected in the community and you have a criminal background. Good luck with all of that. None of that is helping, especially the poorest among us. I think this has been the most, if you want to use marijuana and legalize it because you like it and you love it and it's God's gift, that's one thing. But to be saying you're doing it for reasons of equity, if anything has been shown over the last 10 years, that has been shown to be wrong.
So I agree with a lot of what you said. I think there are a lot of fantastic points being made there. I think that we have massively overpromised how this is going to benefit people of color and really all of the poor people who have sort of been penalized for being dealers or using cannabis. Because we're just not seeing that kind of justice being done. I think also like I think it's really hurts the legalization argument to ignore the harms. There is no doubt that high potency products and synthetic cannabinoids can be incredibly harmful. But again, and I don't mean to keep beating the alcohol drum, but there are very high potency alcohols. And then there is like a low dose shandy, right? That's a mix of lemonade and beer. So in the same with cannabis in these state legal programs, and I'm not even going to say like do it all medical. Let's say just within recreational programs, you can get a low dose pill that's 2.5% or 2.5 milligrams of THC, or you can get a very high dose product. So the idea that everyone who's using it is using like an incredibly strong product is wrong. I think that we actually could and we should regulate this at the state level. And as a lawyer who works in state legal programs, there is actually a huge amount of regulation. Is it working perfectly? Absolutely not. And is it killing the illicit market? No, it's not, but it will over time. Because right now, how many people are making bathtub gin? Like, of course not. You just go to a liquor store and you buy alcohol there. Over time, the illicit market goes away because you have actual avenues for selling it. And then you need regulation of the dangerous high dose products. But I don't think that's an argument for just making it all.
But would Vincente, and I always forget Vincente Cedar, with Vincente, I think it's called now LLP, would it, I mean, help us? Great. Would it help us get, maybe a 15 or 10% THC limit in Colorado or in states where we want a THC limit? Because if so, that's a great place where we can work together. We know it's not going to be, we're not trying to recriminalize marijuana. We know it's not going to be made illegal tomorrow, especially in Colorado. But can we get these 99% THC products, these 70% THC products that are causing psychosis off the shelf? By the way, drug dealers, very bad people, but they never produced 70% THC. They never produced pot gummy bears attractive. They never did the Doritos and the Lucky Charms. So yes, I don't like the underground drug dealers, but they did not do what this legal industry has been allowed to do under the sort of guise of safety and regulation. Nothing's been regulated. I mean, there's no THC regulation. So would you work with us to do that?
Well, me personally, I am in support of it.
Right.
My firm, I can't speak for them. But I personally, yes, I would like to see products that appeal to children not being sold. But in New York, there are really strict regulations on whether or not a product can appeal to children. The problem is that you have all of these illegal dispensaries that are operating, and they're starting to crack down on that. But if you have legal dispensaries that are regulated, that does drive out the
We warned about the illegal market will go up when you legalize, not down. No one listened to us, and now look at the mess we have in New York City.
I don't know that it did go up is the thing.
Sergeant.
Oh, no.
No. Dr. Grinspoon's been trying to get in.
First of all, before we legalized, 100% of the market was illicit. Now it's about a third, and it's going down. So it's like obviously we're making progress. And a couple notes on potency. When I was growing up and listening to the legalization conversations around my dining room table with my dad and all the other legalization people, whatever, Carl Sagan, Andy Weil, and one of the criticisms of cannabis is that it was 2%. You had to smoke a whole joint, and that was bad for your lungs. Now the criticism is too potent. And the plant can't win. I agree. I'm not a big fan of like the 99%
That's right.
concentrates. But the fact is, if you're around more people that actually use cannabis, you'd understand. People titrate,
I live in New York. I'm around them all the time.
Titrate to their own comfort level. People don't just smoke more and more and more and more and more.
That's not what the data is showing.
A puff, some people take 2 puffs, and it's a small minority that are addicted that blast their brains out with concentrates. None of us are in favor of that. And I think that it's really important not to exaggerate the harms because nobody listens to us. If you keep in mind that the research in cannabis for the last 50 years has been done on illegal cannabis, and it's been done on smoked cannabis. National Academy of Sciences, Engineering, Medicine said there is an association with low birth weight babies, but that's probably because of smoking, not because of the cannabis. So we need to redo a lot of this research. And then you say things like it increases anxiety, increases depression because it's associated with this. The same thing with antidepressants. People who are anxious, people who are depressed use antidepressants, right? So they have more anxiety, more depression, and more suicidality. Nobody's arguing that the Prozac is causing the anxiety and depression. It's so backwards. And the IQ loss is just nonsense. They had a study that showed IQ loss. Then they reevaluated the data and they're like, oh, let's factor in other drugs and tobacco and poverty. And the IQ loss completely disappeared. And the final thing is about potency limits. If you cut potency and legislate it from 10%, 20% to 10%, that screws the people on fixed income that are using it for medicine. They have to pay twice as much. The veterans, the older people, and they can't afford it anyways. And we don't want cannabis to be another treatment for just the well-to-do. And then furthermore, that just drives it into the illicit markets. That's just not the way to go. We can't keep making the same mistake over and over again with like overly criminalizing it. We need to shut down the illegal stores, certainly, and try to shrink the illicit market. But I don't understand how we're arguing to repeat the mistakes of the past. It just doesn't work.
I don't want to repeat the mistakes of the past, but the illicit market has ballooned in all of these legal states. For those that are clapping, look at the illicit market. Go to California, look at how big the illicit market is. Go to Oregon.
Has it
look at how
ballooned
big
or has it come above ground?
I'd rather have 5% of people using 100% underground market than 25% of people using.
Okay.
That.
But wait, let me just ask this, because Professor, I think we're at an important point here.
Doing what? We're on a panel talking. Do you want to come up?
No, hold on. Let me ask
Listen
my
to the
question
panel.
here.
One against four. We're just trying our best.
No. And I'm trying to give a balanced approach to it, and I apologize if anybody feels I'm not. But Professor, an important thing has come up because if it reschedules, it doesn't decriminalize on a federal level. If it deschedules, does federal law still have a say through the Food, Drug, and Cosmetic Act? Or is there other federal regulation that's still going to have to be contended with that would at least prevent the Lucky Charms and Doritos, where it's trademark misappropriation, where people are putting out, packages designed to look like that are attractive to kids, which New York has very heavily tried to regulate against or pass regulations to prevent that type of marketing. What is it that comes into play if we end up in either rescheduling or descheduling that gives federal teeth to try to monitor or maintain the standards within the market?
Well, I think it is an important point to recognize. I mean, we're spending a lot of time talking about rescheduling, and I think it's important to recognize that the actual practical impact of moving marijuana from Schedule 1 to Schedule 3 is going to be really, really small. And in part, that's because the Controlled Substances Act imposes a lot of regulations on Schedule 3 drugs. It is legal in some circumstances, entirely legal to possess, produce, and sell such drugs. But first of all, only for medical purposes. So if you're an adult use marijuana purveyor, state licensed, you get no benefit from rescheduling because it only allows the sale of this for medical purposes. In addition, the CSA requires you, if you are handling any controlled substance, you have to get a registration from the Drug Enforcement Administration. You have to get a license from them. So all these companies that are licensed by the state right now will have to go back to the DEA, get a license from the DEA. And what's more, they'll have to actually deal only with other licensees. Because it's a closed system, a closed loop system where registrants can only deal with other registrants. And what's more, there's actually language in the CSA that suggests to the DEA you shouldn't give a license to handle a controlled substance to anyone with a prior criminal record, which could have a disproportionate impact even on those state licensees, those people who have gotten a state license who are in the social equity market. So there's a problem under the CSA if you move it from Schedule 1 to Schedule 3. There's an even bigger problem that is going to persist whether you move it to Schedule 3 or if you deschedule it altogether, which is that we have that other statute out there, the Food, Drug, and Cosmetic Act, that's going to continue to ban the sale of marijuana even after rescheduling. And that's because the FDA, when it announced that it had found under the CSA, marijuana now has a currently accepted medical use, the FDA went out of its way to say, it's still not good enough for the statute that we administer. It's still, this doesn't constitute approval under the Food, Drug, and Cosmetic Act. And the Food, Drug, and Cosmetic Act bans the interstate sale of any drug that has not been approved by the agency, that doesn't have the science behind it demonstrating a medical efficacy. And I think for that reason, every sale of marijuana, even for medical purposes, even if you have a DEA registration after rescheduling, every sale of marijuana is going to remain unlawful. Therefore, all your funds are tainted. Banks still won't want to deal with you. You still won't be able to register your trademarks under federal law because you'll be flouting the Food, Drug, and Cosmetic Act. Still won't be able to file for bankruptcy and so on. Ultimately, I think rescheduling, moving marijuana to Schedule 3, really amounts to no more than a tax cut for the industry, which is important because that weird provision of federal law, Section 280E, only applies to Schedule 1 and Schedule 2 drugs. But beyond that tax cut, I don't think it's really going to do a whole lot. So whatever concerns you have about marijuana kind of ameliorates those. Whatever hope you might have held for rescheduling, well, this kind of bursts your bubble. So kind of hate to say that, but I don't think it's such a big deal as a practical matter.
I will say for the businesses operating in the cannabis space now, the removal of 280E is a game changer. So even though, as I went to college in Texas, as we would say, it's an ass backwards way of improving the cannabis industry because it doesn't actually make any of these businesses legal. You're absolutely right. But if you can remove that incredibly punitive tax regime, like it allows these businesses to operate. And also, I think you're going to see more banks just because it creates this sort of change in the social climate. I think we could expect to see some change in FinCEN guidance for banks that are choosing to work with state legal businesses. And I don't know that Citibank is going to get in on it, but I think you're going to have more state level banks moving in. So I think that we will see tag-along effects from it, but no, it's not being done in the right way.
You think it'll
legally.
make it safer because it's less cash transactions?
There aren't that many cash transactions now. Like that's pretty much a thing of the past. Everyone is either using some sort
Like a
of
bank card.
yes, a debit card or something like Dutchy Pay. There are these programs that allow you to but it's all through debit cards or so I think that it would be nice to see credit card companies get into the space. And if we do have a change in FinCEN guidance, then that could possibly happen.
Yeah, no, we're getting excited up here. So I apologize. I was talking over somebody because we all want to hear. I was told we also want to get into a nice debate and discussion. So I think that's very telling and we're in agreement. I hope you all understood what was just said by the folks on my right, which is that if it is rescheduled, the only thing that's going to be happening, which is a big deal to the big marijuana companies, they get a big fat tax cut. And that is another example, this idea that rescheduling, or I would argue also legalizing, is sort of helping poorer communities, helping mom and pop shops, helping. It just is another example of actually, in this country, that is not going to be happening. And, we're promised all that. I do have one concern, though, that I wouldn't make that Rob said, so that should be my only concern. The other concern, though, is we know how much ignorance is around what rescheduling means. And so I worry about the message I worry about the headlines being federal government now thinks marijuana is more harmless than it was, when the science, and this is why I get excited with my friend Peter, and we're friends off stage, so we get into good discussions. But this is where I get frustrated because what he's saying about IQ and these things are just not, again, don't take our word for it. Please read the medical literature yourself, read the national academies yourself. Is that we're going to see that kind of ignorant headline around the country where it's, feds lower classification of marijuana. Well, what does that mean? Yeah, maybe legally it doesn't really mean anything. Like you can't go buy pot now legally. It only really means the tax cut, which I do think is a big deal, but that's it. But I do think to young people and the people that we're trying to discourage, it's just another PR win they don't need. Right now, marijuana is having a cultural moment. It's having it's the opposite of tobacco in terms of its PR, which is ironic. And that's a worry about rescheduling that is sort of intangible, not legal. Can't really argue that in a courtroom, but I think is something that's real.
But if I can just add something there, really the philosophy behind that, and honestly, the philosophy behind the CSA itself is that consumers know what's best for themselves. And that some paternalistic government entity, be it Congress or the DEA, is going to be the one that determines what they have access to. It's a philosophical bent. You can accept that as long as you're transparent with that. I have respect for it, but there's a more libertarian approach, which is that what we do is we put on the table and we warn people and we tell them here are the possible benefits and possible risks, and we let them decide for themselves whether they get it. The CSA doesn't allow that. The CSA basically says we know better, and you're only going to be allowed to use this for medical purposes alone, and then only if, under the DEA's interpretation, only if scientists agree it's really good for you, and actually helps you with a medical condition. But there are other philosophical approaches to that would say, hey, we know there's some risks to this, but it's up to the consumer to decide whether a hit to their IQ or psychoses or something else, and we'll only intervene when the individual is actually going to harm someone, and only then to the extent necessary to do so, like pulling you off the road or something like that, not by throwing people in jail or criminalizing or even civilly banning all production, possession, and distribution of this substance.
So Jen, a question for you, because so clearly there's a view that other than 280E, there's not a lot of great advantage in rescheduling. So descheduling is also part of the conversation of the panel here today. What are some of the impacts particularly on an international scale with treaties and so forth that would be impacted if descheduling versus rescheduling?
Oh, interesting. I think rescheduling, we certainly can accommodate our treaty obligations because it's really quite consistent. In fact, it would make it more consistent than the system we have right now. Descheduling, I mean, Congress has the power to do this, right? Like when Epidiolex first came out, it was derived from a Schedule I drug, cannabis, and Congress decided, like, no, this is actually going to be okay. And there's the UN body that oversees that is a quasi-judicial body that sort of enforces the single convention on narcotics. They don't actually have any real enforcement power like many other UN bodies. So when Uruguay and Canada legalized, there's really not much they can do about it. And the US created this state legal system. There's not much that they can do about it. So rescheduling, I would like to see it happen with a move from Congress. I don't see the Attorney General just completely descheduling. That's my gut feeling on this. I think it would have to come from Congress actually passing the States Act or one of these other legalization frameworks, and then you would have this ability. I would defer honestly to Robert on and the other panelists on how that actually would work in practice in terms of what regulatory frameworks need to come in place to adhere to our treaty obligations.
So one thing that, comes to mind is that this hearing is not scheduled until December 2nd, and that obviously is to await the outcome of a presidential election. So that may change things slightly. I don't know whether it will or won't. But if, let's just say that they stay a decision on this or stay the hearing for a year or two, let's talk about then recent rulings that have come up. And a lot of talk has taken place within these panels about the federal 2018 Farm Bill and now what are cannabinoids that are outside the realm of control, and what are the same concerns and dangers that have been raised about Delta 9. At least we've been talking in the context of Delta 9 and cannabis, but what are about these other cannabinoids coming out of the hemp? And Peter, yeah, go ahead.
The Farm Bill was, as we could all agree, a case study in the law of unintended consequences. And what really worries me is, I think some of these products might have medical benefits. They need to be studied. Delta 8, Delta 10, very close to Delta 9. But it's absolutely crazy that we're producing these with no adult in the room. Nobody's controlling the manufacturing. No one's controlling the sale. Some states don't even have an age limit. You could just buy the stuff. And, I think both sides should be against this. I think the pro-cannabis people should be against it because it really sort of muddies the water and gives legalization of regular cannabis, which we've been using as a society for 10,000 years, a bad name. And the anti-cannabis people have a very, very strong argument for this. And it just needs to be regulated. And some of these synthetic THCs that are being developed, like THC zero, really potentially really dangerous. So I'm really, really concerned about this. Of course, there are many different components of it. They've studied the use of Delta 8 THC is higher in states like Texas where they haven't legalized cannabis. So I think to a certain extent, this is an argument for just legalizing and regulating cannabis so that there's less of a need. People want the medicinal benefits or to approximate the medicinal benefits of cannabis using these really shoddy products like Delta 8 THC has who knows what industrial byproducts in it. You don't even know if you're getting Delta 8 THC. It's profoundly dangerous. And if we either, but again, criminalizing it is just going to put it, I don't have a great solution because if you criminalize it, it just goes into the gray market and it gets more dangerous. Law enforcement, the public health officials have less of a grasp on it. So I really think we've got to find a way to regulate it, but I don't think anybody really understands how to regulate it. So I could really appreciate the problem. I think the problem would get better if we actually had legal access to cannabis, just like I argue if we had legal access to opiates, people with chronic pain and people with addiction wouldn't be buying fentanyl on the street and overdosing. We wouldn't have anybody overdosing. So I think if we had a safe, regulated supply of these cannabinoids, the cancer patients, pain patients, insomnia patients want, people wouldn't be using these things. But again, Governor Newsom just had a bill to ban it. And I had to say, I'd say I'm more support it than oppose it, but I don't think it's a cure-all. I think we just need to regulate these things. It's sort of like Pandora's box is open. These things are out there. People have discovered them. They're going to keep providing them. We've just got to find a way to make them safer.
Kevin, I know you had a response on treaties, and then I'm going to start opening it up to the audience because there are a lot of people, particularly that have hemp concerns and hemp practices out there. But Kevin, I know on treaties you had something to say.
Also, though, real quick on that, I do think you either discourage or encourage. And while you will not eliminate drug use with a kind of prohibition, there's a reason why the level of marijuana use has gone up so much in the last 10 years because more states have legalized it. Doesn't mean no one's going to do it if it's prohibited, but you either encourage or discourage. And that's the rule, but you don't want to, while you discourage it, you don't want to go overboard, which I agree we've done with the war on drugs. So it's about finding that middle ground. On treaties, I know the UN is probably, less popular, if you can believe it, than our own government in terms of like enforcing international law. So this is not going to go over well. But I do worry about rescinding our UN treaty obligations. These were very important treaties, 1961, 1971, 1988, that the U.S. passed. Almost every country in the world has signed. Canada's out of its obligation, but almost every other country in the world has signed. And my worry about just like, well, we can do it and they can't really do anything to us, so it's okay. We can just, just violate it and we're not going to have a consequence. My worry is not so much like, will that INCB body that Jen talked about, like, will they come and enforce quota limits on opiates, which they could do, but they wouldn't probably do that. My big concern is, where does this lead in terms of our other treaty obligations? There's a lot of other treaties, nothing to do about drugs. If you care about climate change, if you care about the rights of the child, if you care about the way we deal with, different parts of the environment, if you care about our treaties with regards to nuclear, the nuclear issue, many issues that I would argue, and I'm going to be in the deep minority, it is good to have a global agreement and consensus on that. Now I'm hearing, because I go to the UN, I've been going for 20 years on this, usually with the government, lately without, now that I've not been in government. But I'm hearing other countries say, well, like Russia, for example, well, if America's not going to fulfill its drug obligations, which it's the #1 drug using country in the Western world, next to Canada, then you know what? We don't have to do our obligations on that treaty, or China on the environment, or here on nuclear. And so I sort of worry, maybe that's an overblown worry and no one will pay attention to the drug treaties anyway, because they're usually pretty down on the list of priorities on the global issue. But I do worry about like what implications that has when we're just like, yeah, we signed all these things, but whatever, we're just going to violate them and move on.
Well, I mean, the cat was out of the bag after the Iraq War.
Well, and other countries, other countries are legalizing. Germany, Canada, Uruguay, Colombia, and many more countries will be legalizing the next 5 to 10 years. I think some of these treaties were for a different era, and they sort of outlived their natural usefulness.
Yeah, I mean,
I would make one quick suggestion here, which is that the treaties have more bite, I think, than we're letting on. Not because there's some international body that's going to come invade the United States if it abandons the treaties. Instead, the Congress that passed the CSA and the Nixon administration back in 1970, they incorporated the treaty obligations into domestic law. And domestic law is not something that the president can just waive. The president can back out of a treaty anytime the president wants. The president can't just ignore domestic law. So the CSA says anytime you're scheduling a drug, you have to adhere to any affirmative obligations imposed by international drug control conventions. And that's been a sticking point for rescheduling marijuana in the past. The DEA took the stance that international conventions, they require us to keep marijuana at least on Schedule 2, nowhere below that. The OLC, again, has taken a different view of that. It said, well, you could move it to Schedule 3 as long as you pass some new regulations to meet our obligations. But the point here is that it has teeth. We can't just ignore it unless the president engaged in some nuclear option and said, we're pulling out of that international convention. Then it would no longer apply. It would no longer be part of domestic law, but nobody's talking about that. So it is enforceable, but for a different reason. It's not about concerns about deterrence and other nations and what they might do. It's that a court would order the agency back to abide the treaty.
Just so I understand, so my read of the OLC opinion is that if it is moved to Schedule 3, the DEA would need to pass some or enact some regulations that would allow for them, that mostly deals with import and export control. So, I mean, it is possible to bring it into alignment with the treaty obligations, or do you think no?
Yeah, so what the treaty does, the treaty actually doesn't say you've got to keep it on Schedule 2 or 3 or whatnot. Instead, it says here's a laundry list, a catalog of controls that you have to impose on these different substances, including cannabis. And under domestic law, there's a different set of controls that applies to Schedule 1, Schedule 2, Schedule 3, and so on. In the past, the DEA said, well, we have to keep it on Schedule 2 because one of the controls that's required by international law is impose quotas on cannabis. And we only impose quotas under the CSA on Schedule 1 and Schedule 2 drugs. So if we move it to Schedule 3, ipso facto, we're out of compliance with the international conventions. But the OLC came back and said, no, you've got the regulatory authority to impose quotas on Schedule 3 drugs. So do that. You don't have to keep it on Schedule 2 just to abide international conventions. Move it to Schedule 3, pass these additional regulations on import, export, and quotas is the other big ones.
So let me just jump in because this has been an incredible conversation, but I know there are a lot of questions actually out in the audience. So, and I know Dave Sergey, you had a question.
Well, first of all, I'm going to make a point about the international treaty obligations because I represented and was part of the team, the Avena case, consular access case in front of the ICJ and then the Supreme Court. And unfortunately, I don't think our courts really give a damn about treaty obligations anymore. And as much as I would like to argue treaties, I just do not see it because International Court of Justice explicitly told us to grant consular access to Mexican nationals. They didn't, and our Mexican nationals got executed. So more to the point, and my question, it really comes down to hemp. And I've heard a lot of talk about social equity. I've heard a lot of talk about safety. And I come from Texas, so we're a TCHA red state. We politely call it red state weed. However, what I have seen in Texas is in the absence of government regulated, mandated regulation, that we actually have a much more equitable system of distribution by using hemp, low barriers to entry. We need more regulation. We need to make sure that we don't sell to kids. We need to make sure we have age gating, which, by the way, the Texas legislature has refused to do and now complains about the fact that our kids are being sold to. But I think we really need to reframe this discussion because the Veterans of Foreign War, their executive director and their director of policy on a national level is fully in favor of hemp-derived cannabinoid products if they are properly regulated. And I think that's really the disconnect in the conversation because we have this, what I would call war between the MSOs and between hemp producers. And it's really silly because at the end of the day, hemp, at least in Texas, is a very accessible product that almost anyone can get a license to sell for the $150. The problem is, and it goes back to the communities of color, the various communities where people live. And at the same time, we're not requiring enough training. We're not requiring enough education for the sellers. And we're not requiring enough barriers for children to come in and purchase. So we don't, for example, part of the bill in the legislature that I'm working on will require a age verification gate check at the door. That will eliminate gas stations. That will eliminate a lot of the people that abuse the system. But to throw the baby out with the bathwater and say, hey, we don't know what's in this stuff. I represent some producers that produce ethically sourced, appropriately produced, safe product. And we need to encourage that as opposed to saying Delta 8's bad, Delta 9's bad, Delta 10, THCO is bad. I mean, I'm the guy that kept Delta 8 legal in Texas.
So just I'm trying to understand the question though. Is it that there should be state regulation should be deferred to when it's ethically sourced and this has been set up?
Yes.
Or should it be a federal regulation that comes into play through the Food, Drug, and Cosmetic Act?
Exactly. Because to me, having state regulation that is, I mean, I'm not opposed to federal regulation, but in our current, where we are now, we at least need to have appropriate state regulation that requires safe food handling, that requires, seed to store COAs, that requires safe practices.
Okay. So just because, I mean, that's a whole conversation in of itself,
Yeah,
and
I know.
I would
Sorry.
very much like to engage in it, but I know there were other questions out here. So, Dale. Oh, sorry. Go ahead. You all control it. I'll just.
Okay, I'll be quick. A couple of things I was just kind of jotting down in the conversation. One, I agree on the regulation. I think we can't, the issue is, and particularly for, you were talking about companies and businesses that are good actors and they want to be regulated. They're following the rules. They have safe products. We hurt those industries when we just throw everything out. And I'm from South Carolina, so we're like the last to do anything. And we're still trying to pass medical cannabis. And to the point of rescheduling, to those that say it doesn't, it helps medically, because now that so many doctors and medical professionals have come out and talked about how beneficial it is, patients, the only reason we haven't passed it is because they can say there's no medical use. And so by rescheduling it, it will then, there will be no other than just saying we just don't like the idea of marijuana. Then they can't hide, we can't hide behind that as a legislature. So it doesn't help recreationally, I agree, but on the medical front, it does do that, because now you can't say that there's no use for it for us to do medical cannabis. Also, there was a comment
If I
about.
can interject, you could. I mean, right
Well, that's
now,
what
you
they're
as
using
a
as-
state lawmaker, you could go back and say there is currently there is a legitimate medical use.
Oh, yeah.
That's what 38 states have done. So
Right.
you're not bound by what the federal government
Well-
does. And even after rescheduling, a doctor might come back and say, well, yeah, the FDA said there's a currently accepted medical use because it's popular, but the FDA hasn't approved it. So there's really no medical use. So I think we're using too much federal scheduling as a crutch, as an excuse to make proclamations that we support for other reasons.
Well, we're using
rather
it,
than,
well, not we're,
yeah.
but the majority in our state is using it to not even have the conversation on medical cannabis, period. And so I think that would be helpful in that for the states like South Carolina. And there was another, somebody about the arrest. Oh yeah, legalizing. I think somebody said that legalizing marijuana, now there are more arrests for marijuana. I'm not sure how that works, but because if it's legal, then you can't. So you're saying there are people being arrested for
so
it?
in Colorado, we've seen an increase in youth arrests for marijuana after legalization, because there were arrests related to public use, there were arrests related to using it at school,
Okay,
there were
like
arrests
that.
related
Okay,
to driving.
gotcha. Okay.
But also the National Academies on Friday said that the disproportionality, the level of disproportionality went up overall since legalization in terms of, because there are still arrests happening. I mean, it's not just not supposed to be a total free for all. Public use, driving, minors, a lot of things, selling to minors. I don't know if people realize alcohol is the #1 drug for arrest in this country every year, much more than all illegal drugs combined, because of selling to minors, using in public, and DWI. That's a legal drug that more people are arrested for than all illegals combined. So
Right.
illegal drugs. So that's
No,
how
I agree with you on that point,
That's just-
but on the decriminalization of it, at least from what I can only speak in South Carolina, it takes away the pretextual. Well, I'm going to stop you because of marijuana, or I say I smell it, and so I'm gonna. So it takes away that, and I see it all the time where, and we talked about this at the panel earlier, where it's so subjective, and law enforcement will use that.
Well,
And
I have a feeling they'll find, if they want to use it, they'll find 15 other ways to use it.
they will.
And that's exactly what's happening.
But
in
if we
other
take
states.
that tool
The-
away,
the race issue on the criminal justice system, we've been doing this for 15 years in California. It hasn't happened in Colorado. It's over 10 years. It's more disproportionate now, not less.
Peter?
I just have a couple quick points. The arrests have gone down. They're still way too high. About 5 years ago, there were 400,000. During the Reagan administration, there were 800,000. Last year, there were 200,000 arrests. So on the one hand, it's way higher than it should be. The vast majority of these arrests for nonviolent possession. So at least we're heading in the right direction. The rest are going down. It's going to help everybody. And then also, we need to point out that most states that have legalized are working very hard on expunging records and doing things to repair some of the damage. We can't repair all of the damage. It's been catastrophic, but to repair some of the damage. So we are making progress. We all agree that we're not making as much progress as we could be, but things are definitely getting better. The more we wind down this like incredibly destructive and racist war on drugs, work on reparations, have fewer arrests for nonviolent possession, the better everybody's going to be off. So we're getting there, but it's very slow.
We're all in favor of expungement. Expungementing of records. I work with Patrick Kennedy on that. We want that to happen. My point is, why do we have to commercialize and promote marijuana and have, frankly, rich Wall Street guys get richer in order to have the conversation on expungement and pardoning? Like, you can do expungement and pardoning without promoting an industry. That's where we would probably differ. But I want to make that point because, again, we're often conflating legalization with expungement and war on drugs and reversing it, and they don't have to be the same thing.
On the rescheduling point, though, I think one way in which it would lead to a more equitable industry is 280E tax relief, because I don't think it disproportionately benefits MSOs, and quite to the contrary. The MSOs multi-state operators tend to be vertically integrated, and they are better able to weather the really difficult situation that the cannabis industry is in versus mom and pop stores. If you're just getting a dispensary license, like in New York, if you get a card license, you just have a dispensary, right? You have a social justice background. You are being hammered by taxes because your cost of goods sold is really a relatively small proportion of your total costs. So I think counterintuitively, it actually would help small businesses so much more. So I don't think that, I would just like to see that go away and allow these operators to actually have a chance at success. Because right now, the way the tax regime is, the small operators are going to go away in the next 2 years.
I just want to point out, though, and we can all have our opinions on the cannabis and whether it should be commercialized or not, but if it wasn't until 2019, it may have been 2018, but I believe it was 2019, New York didn't have an expungement statute. It was the conversation about that. And that is what makes it important. So it's an important conversation in whatever context it comes in. Should they be separated out? There absolutely should be expungement. But a lot is owed in New York State to the conversation about cannabis, and I think it's important, particularly issues and concerns about equity and recognizing the over-policing, over-enforcement, particularly on particular communities. Dale.
Yeah, let me just say briefly to Kevin's point about in California, at least, the total number of cannabis felonies is down by over an order of magnitude, and most of those people are minorities. So there's been a huge beneficial impact on that much, at least. But as to rescheduling, I wanted to follow up on what the senator was saying before. There are a lot of medical cannabis patients out there who I think would benefit just simply from the recognition that this is a medicine, because we hear all the time from patients who are trying to convince their regular general practitioner that, you know, it's good for them or it would make sense for them to use cannabis, and the GP will not hear about it. Hey, this is a Schedule I drug. There's no medical use. You know, I won't have it, and hospitals won't allow it on the grounds, and so on and so forth. So I think it would be certainly beneficial in that respect. And also, I guess there hasn't been much mention about the research restrictions on Schedule I through Schedule III. There's some improvements for researchers under the Schedule 3, especially, I got to say, in California, because it relieves researchers of having to go through an extra round of review by the California Research Advisory Panel, which has delayed and derailed studies quite a bit. So I think that's another advantage of the Schedule 3.
If I can just make two quick points along those lines, we're on the research. I mean, ironically, Congress passed a law maybe a couple of years ago now to try to expand research on marijuana. I think that law would trump whatever regulations are otherwise imposed normally under Schedule 3. And ironically, we might have been better off research-wise if Congress had never passed that statute. If it becomes Schedule 3, right? If it doesn't, the statute was great.
We helped write that
it does.
statute. So under that Schedule 1 context.
The other with respect to patients, I agree, and I recognize that moving it to Schedule 3 and maybe recognized under the CSA that has a currently accepted medical use, maybe that'll encourage some doctors to take another look at it. Although I remain skeptical because they'll still say it's not FDA approved. But there is one set of patients that'll definitely benefit, and that's patients with the Veterans Administration. Because the VA has said explicitly, our physicians who are employed by us, and they can do this, our physicians will not discuss marijuana with their patients because it's Schedule 1. All of a sudden, if it goes from Schedule 1 to Schedule 3, that rationale no longer applies. The VA at least will have to reconsider that. And what that means for VA patients as a practical matter is they have to go out and find another doctor to recommend marijuana as a treatment. Maybe this will change that. So there are other beneficiaries besides the industry. I still think, though, that the benefits are maybe less than we might have thought, or the impact would be less than we might have thought going in.
Okay, we have one more question, and then we're going to take a
one
break.
comment.
I just want to addendum. I hope veterans don't do that, because the largest study done on veterans and PTSD, Yale University, please look it up, showed that marijuana, at least among this sample, which was a large sample, it exacerbated symptoms of PTSD. Doesn't mean that there might be certain kinds of marijuana in certain, that are maybe formulated by the FDA that are passed or later used for that. But what we're seeing about the effects of PTSD, again, please look it up yourself. I think it's been a real disservice to our veterans to sort of, with this PR campaign, to say that marijuana is good for them.
Okay, so
that would be subject to anecdotal. There are a lot of vets that would take issue with that. And there are
we're
some
going to
here
cut
today.
this off because we have another breakout session. And we have one more question, and then we're going to take a break so everyone can do what they need to do. And then I will let you know where the breakout sessions are. Carolyn.
So I'm asking this question purely from a lack of knowledge and understanding as a non-user, the potency that you've been talking about. So for our medical doctor, is there a medical condition that's treated with cannabis or THC at those 80%, 90% levels? Is that current practice?
Well, people have different opinions on that. I think some people with chronic, some veterans with traumatic brain injury, and some people with very severe chronic pain, and some people with phantom limb could require very high doses. We usually start with very low doses. Everybody's very different. That's one thing that makes cannabis medicine a little 2 milligrams for you, 50 milligrams for you. So I would treat them with like edibles, very stronger edibles. I wouldn't recommend smoking the concentrates because, first of all, it's just not good to smoke unless you could avoid. If you're a cancer patient who's dying, sure, you could smoke, but generally speaking. So I think you don't need the concentrates necessarily to have high levels of THC, but that some people do require very high levels of THC.
Are there any other questions? Otherwise, did you have one?
I think we're wrapping it up.
Okay.
Sorry. Yes, thank you.